Today we look at and consider the newly passed Self-Contained Motor Vehicles Act and what enforcement of that means at a district court level. To be sure, courts can, and often do, refuse to enforce legislation, or law if you like. Grounds for district courts to do so have been established by higher courts over a number of decades. Judges and legal professionals often say that the law is an ass. Courts are actually unable to find legislation unlawful, but can make a declaration of inconsistency. The courts being widely separated from the corridors of power, i.e. the beehive, as demonstrated recently by the departure of Minister Nash. High Court proceedings undertaking a pre-judicial review of legislation will only find inconsistent legislation, not unlawful legislation. The grounds for this legislation, as passed, is stated as being to reduce incidents of public defecation. So what grounds are available for a court to refuse enforcement of legislation, and what does it actually mean with this legislation as passed? The Bill of Rights is the first and potentially the most obvious one. The principles of the Bill of Rights state that restrictions on rights should, at a minimum, be 1. Provided for and carried out in accordance with the law. 2. Directed towards a legitimate object of general interest. 3. Strictly necessary in a democratic society to achieve the objective. 4. The least intrusive and restrictive available to reach the objective. 5. Based on scientific evidence and neither arbitrary nor discriminatory in its application. 6. Of limited duration, respectful of human dignity and subject to review. Certified self-containment has never been a justified restriction on a right, and that has been evidenced by the attachments to our select committee submissions, whose staff, interestingly, conveniently lost them, so they were not considered by the committee, but are now available online. I should put up a link to those submissions in the introduction to this video, but essentially it proves that there is no evidence of benefits or reduced health risks just because a camper is self-contained in any of the many forms of which certified self-containment has been presented in over the past over 50 years. As such, this law has nothing to do with hygiene or reducing health risks, so that criteria can be ruled out as an excuse for its use. Now remember the grounds for this legislation and the criteria needed to restrict the right. There has been no evidence put forward proving freedom campers of any type are to blame for public defecation. Remember the requirement requiring scientific evidence? Who is it? RCAI, for the record, do not doubt that public defecation is an issue, and perhaps a very small minority of freedom campers could share some blame in that. But as often evidenced on our own social media groups, it mostly appears to be members of a certain club, of whom now 100% are reported to be certified self-contained. About 4 years ago, Gilwyn Davis, then Tourism Minister, had installed at some freedom camping sites cameras in order to capture incidents of camper irresponsibility. So where is that evidence? Surely it's the most basic requirement in order to pass these laws that evidence is provided. By the very notion that this government seeks to address incidents of public defecation, but refuses to amend the Section 32(2) of the Summary Offences Act, raises the question and potential legal defence of inconsistency and confusing as to what the goal of this legislation actually is. Meantime, rights criteria to be the least intrusive and restrictive to achieve the goal is often overlooked, that being the provision of more roadside toilets for use by all the travelling public and the use of education and accreditation programs. While even government ministers addressing the House and attempting to justify the bill, as it was then, resort to comments like these made by Minister Nash with no connection whatsoever to freedom campers, also helps to establish a legal defence to any infringements issued. Quote, I saw 2 fixed toilet camper vans there and got to speak to the people there. I didn't have a problem with what we were opposing. Obviously not, they already had them. As I returned to my car, I noticed human faeces and toilet paper at the rest stop. This is a rest stop. This is not even a freedom camping area. It's got no tangible links to freedom campers. Unfortunately, this is the degree of evidence that this government has raised. As such, this makes this legislation manifestly unjust and harsh. Remember Kelvin Davies' cameras to collect the evidence? Where is it? It has often been suggested that the solution provided is also a big part of the problem. Its ongoing, obsessive promotion by its developers has, without any doubt, damaged the social licence of freedom camping in New Zealand. With a majority of complaints received by councils being about certified self-containment, with zero link or suggestion to actual camper irresponsibility. The list goes on, but there are many reasons for courts to not uphold this legislation. Most, if not all, has been discussed over the years in our social media group, Uncertified but Self-Contained Camping New Zealand. I shall put a link to that group up in the video introduction as well. To finish off, grounds for the court to not uphold legislation include, but are not limited to, 1. Manifestly unjust and or harsh. 2. Non-compliance with the Bill of Rights Act. 3. Contradictory or confusion around the goals of the legislation. 4. The objects of the legislation will be met or will have the opposite effect as this legislation will do. 5. Does the law make something illegal which is otherwise provided for in law? Remember that Section 32 of the Summary Offences Act that the government refuses to address? 6. Are the solutions provided actually the problem? Yes. Does the legislation or law unjustly affect others, i.e. truckies, homeless and users of the backcountry? And 8. Does the legislation benefit a particular private group without any justification for so doing? As a final thought, well, the government's been very quick in this instance to blame non-certified self-contained campers for roadside defecation. Will they seek another group to blame in 2 or 3 years' time when the legislation has failed to achieve anything? Maybe they will look at certified self-contained campers, as obviously it's only campers that travel the highways and byways. Or, as RCAI would suggest that they understand and they acknowledge now that there is no specific group to blame, and the provisions of more roadside toilets in non-urban areas would go a long way to addressing the issues. I'm sure we can all remember, even back 20 years ago, there was plenty of roadside toilets. All gone now. We have all these new roads, and I live at the start of Transmission Gully. You can literally drive over an hour north from my place and not one public toilet is provided for along that route. Not one. Nor is there any rest area. People will not pull off a road and go into a suburb or a town to find a toilet or a rest area to prevent driver fatigue in an area that they do not know. This is why other countries overseas, and specifically developed countries, which I question whether New Zealand is a developed country anymore, have rest areas and toilets beside their highways. You just pull off a highway into a rest area, you can go to the toilet, you can have a 20-minute power nap, whatever you want to do. There's a case being made now that those areas could also include charges for EVs, electric vehicles. So, you know, there's a lot of scope there for improvements, roadside facilities for everyone, and we need to be looking at that as a goal ahead. Thanks for your thoughts. Any questions on any of RCAI's Facebook groups? You search Facebook RCAI or Responsible Campers Association. You'll find one of our groups and we're happy to answer questions. Uncertified is probably our most controversial, and we probably prefer to keep the controversial stuff to that group. You will have to find that and ask to become a member of that group, which will be approved by admin as long as you meet our requirements.